Hi, my name's Faye and I'm a Senior Surveyor at Harrison Clarke Chartered Surveyors. I lead our party wall surveying team, and today we are going to be exploring security for expenses and how it relates to the Party Wall Etc. Act 1996. Under Section 12 of the Party Wall Etc. Act 1996, adjoining owners can request that the building owner provide security prior to commencing their notifiable construction works. This is known as security for expenses, and today we will be explaining the basics and answering some common questions that you may have. An adjoining owner may serve a notice requiring the building owner before he begins any work in the exercise of the rights conferred by this Act to give such security as may be agreed between the owners, or in the event of dispute determined in accordance with Section 10. That's a little bit confusing and doesn't make a lot of sense, but there are some key points to note. The adjoining owner must make their request in writing by serving a notice on the building owner. If notice is served, the building owner carrying out the construction works may be required to make a deposit to cover foreseeable expenses that may arise as a result of notifiable works. The adjoining owner and the building owner can agree the type and amount of security themselves without the need of party wall surveyors. However, if a dispute arises, the party wall surveyors will agree the security on the owner's behalf. The security can be in relation to notifiable works, not any other issues that arise from the remainder of the project. Security for expenses is a mechanism to protect adjoining owners from foreseeable damage, either from the building owner failing to complete the construction project or completing repairs caused by their works. Security in the form of money would traditionally be held in a solicitor's account, with an undertaking that the money would only be released on instruction from the appointed surveyors. However, in 2014, the Solicitors Regulation Authority advised that solicitors should not be providing these banking services unless there is a true connection between the recipient of funds and the legal services being provided by the solicitor. Solicitors do not usually get involved in party wall matters unless something has gone badly wrong. As a result, money is more commonly held either in an escrow account, or some RICS regulated firms will be able to hold funds in a client account. When funds are held by an RICS regulated firm, the money will be protected under the RICS Client Money Protection Scheme. Alternatively, security can be made through bonds or insurance, although the use of insurance can be controversial. This is because it could potentially undermine the surveyor's statutory authority to deal with a dispute that arises, as a loss adjuster would be appointed to investigate claims of damage. This could also delay the course of repairs, which can be frustrating and leave the adjoining owner vulnerable to further damage. Security for expenses is particularly beneficial for protecting parties in the event of insolvency of the contractor or party carrying out the works during the project. The Party Wall Act is not specific on what security for expenses can cover. However, it is largely agreed in the surveying community that security for expenses can cover things like repairs to an adjoining owner's property when damage is caused by the building owner's notifiable works, expenses for making the adjoining owner's property safe and secure should the building owner abandon the project, temporary accommodation if necessary and any associated costs or fees, professional fees in relation to resolving the dispute itself, alterations or reinstatement of the works undertaken by the building owner, particularly in the event of the building owner failing to complete their works, leaving the adjoining owner's property vulnerable to damage. And there are some other kinds of things that can be covered, but your surveyor will be able to advise you on this. If the building owner refuses your request for security, a dispute will arise under the Party Wall Act. Party wall surveyors will need to be appointed, and it will be their job to determine whether security for expenses is reasonable for the situation. The surveyors will consider whether security is required, how much security is reasonable, how the security will be held, and the control mechanisms and timelines for using the security or releasing the funds back to the building owner. The surveyors will consider foreseeable damage and may obtain cost estimates from contractors or other professionals to assist in their determination. Once these have been considered, the surveyors will document this in a party wall award. Before the works proceed, the party given security for expenses, usually the building owner carrying out the works, will deposit the agreed sum into the agreed account. Often, security is released in stages as the notifiable works are completed, and the two surveyors are happy that the works have been completed to a satisfactory standard. However, every situation is different, and your party wall surveyor will be able to advise you on the mechanism of release, which is also going to be well documented in your party wall award. It is important to remember that the funds will only be released when agreed by both surveyors. If you are a building owner or a joining owner and have more questions about security for expenses, our team of experienced party wall surveyors are here to guide you through your party wall process. Please feel free to call us on 023 8155 0051 and we look forward to helping you. To stay up to date with all our new videos, why not subscribe?